every question and every word in the question is given for a reason. In every question, every word in the question is given for a reason. First, try to address that, and while starting mains answers, remember a simple thing. If there are 20 questions in the mains paper, if there are 20 questions in the single paper, a single teacher will not correct all the 20 questions in general studies. For example, GS1 you have geography, history, world history, modern history, social issues and other small things, miscellaneous things. So generally a teacher will correct around 4 to 5 questions in each paper. So don't try to allot more time to questions which come in the first and less time to the questions which come in the last. First thing is, it is time management which is very crucial in writing mains. It is not just answers, it is time management. How I have managed my time? I have not calculated the questions which I know, the questions which I don't know, but I have calculated my time. At that time there are 20 questions, each question carried 12.5 marks. Now there are 10 marker questions and 15 marker questions. So what I have done? I have divided my time into 9-minute segments. First half an hour I should have completed 3 questions, I should be in the 4th question. So I have divided my time into 9-minute segments, and I also have done micro planning in my time management, like 30 minutes, 30 minutes, 30 minutes. So if you follow that, you will never miss the bus. Otherwise, in the last 1 hour, you will be writing 7-8 questions which is fatal to your mains marks. So first of all, time management. The time management according to the marks of the question. Now you have 10 marker questions and 15 marker questions. For 10 marker questions, you are expected to write around 150 words. So you are expected to, you divide your 250 marks into 180 minutes. So 250 marks by 180 minutes. So how many marks and how many minutes? This is the most important thing. So you should be able to complete a 10 marker question around 6 to 7 minutes and 15 marker question around 10 minutes. So more than that you should not allot time. This is the crucial thing. The next important thing, you will know lot of information but you don't know how to write an answer, means how to put it in an answer. The issue is, try to write most important things in the answer. How? So now I will take each question and how to complete the answer and how to write introductions and conclusions. Let us discuss. The first question. Supreme Court is overburdened with multiplicity of cases. Supreme Court is overburdened with multiplicity of cases. In this context, explain the need for National Court of Appeal. In this context, explain the need for National Court of Appeal. This is a question. In this question, I will tell you what the mistake the student have done. We have focused more on overburdening and multiplicity of cases and less on National Court of Appeal, which is really faulty. If you write like that, you will get only 4 marks. But for this 10 marker question, you may score up to 6.5 marks. 6.5. Now I will tell you. You should know the data, how many cases pending in the Supreme Court. Those who write with data will get half mark more, this particular data. Okay. According to last year estimate, it was 48,000 cases. This year it was more than 50,000 cases that were pending in the Supreme Court. All criminal appeals, civil appeals and other cases including labor law, law of torts, that is civil wrongs, all these appeals are going up to Supreme Court. But Supreme Court is, as the highest court of appeal, is better equipped to deal with the cases of constitutional law and public law. Constitutional law cases and public law cases. But Supreme Court now is sagging with mundane civil appeals and criminal appeals and repetitive cases. And it was also overburdened. You all know till last month we have shortage of judges also in the Supreme Court. For all these reasons, Supreme Court is overburdened and delayed justice is nothing but denied justice. Definitely this sentence should be there in the answer. Delayed justice is the denied justice, will result in the denied justice. This should be the first paragraph of the answer. In the first paragraph, this should have been completed. And coming to the next paragraph, if you see, explain the need for National Court of Appeal. Actually, I have given this based on 2016 newspaper articles. In the year 2016, there were regular articles including Hindu paper editorial on National Court of Appeal. The idea of National Court of Appeal started in 1980s. And also, even at that time, Supreme Court have asked the government. And later on, slowly, there were various issues about the National Court of Appeal. But I asked about, explain the need for National Court of Appeal. So, first thing is to make the Supreme Court relaxed in its own domain, and also Supreme Court is the best interpreter of constitutional law and constitutional cases. You make this number one. Number two, as you all know, the seat of Supreme Court is at Delhi. Delhi is always a cumbersome, costly and very difficult process to reach, and litigation will become costly if you want to engage a lawyer up to Delhi. So, Supreme Court lawyers. For that reason, National Court of Appeal with its branches, with its seats at Bombay, Madras and Calcutta can have better, will act like a circuit courts, and they are the final courts in civil cases and criminal cases and other labor law and other cases. This is a good thing. But the issue is, the problem is we need to amend constitution, and also there was an argument by Attorney General saying that this National Court of Appeal is nothing but creating extra litigation, thereby filling the pockets of the lawyers. It won't result in really genuine issues. So, National Court of Appeal is not a viable option for India. But in various countries, particularly Western countries, the Apex Court deals with constitutional cases, and a similar National Court of Appeal is present to deal with civil appeals and criminal appeals. So, it is better for India, slowly Supreme Court delegate its powers to, some of its powers to National Court of Appeal through parliamentary constitutional amendment. This was the solution. This is the answer. This is the structure of the answer. Okay. So, question and answer, pinpoint. If you write this much, it is done. So, there are two parts to address: how Supreme Court is overburdened, the need for National Court of Appeal, and what are the issues. So, you have to give equal priority to all in 6 minutes. You can do that. Most important points you can pick up and write. Okay. Next question. What is money bill? How money bills can be differentiated from finance bills? This is a static question to test your static knowledge. How you are going to address your static answers, that's all. See, most of the students wrote the answer about money bill without mentioning article 110 and 109. Most of you have mentioned 110 but missed 109. In fact, 109 is a procedure for the passing of money bill. 109, article 109. In the central level, 110 is money bill in the, which will be presented in Lok Sabha, and also 109, procedure for passing of the money bill. In constitutional related answers, definitely you should mention articles. Without writing articles, you will miss the marks. So, article 110 and 109. And 110 you need to explain in detail, because first part of the question is what is money bill. So, there are clauses in article 110, introduction, abolition, remission, alteration of tax, custody of consolidated fund, giving guarantee out of consolidated fund. There was a detailed discussion, right? and money bills can be introduced only in Lok Sabha with the consent of the president, and speaker decision is final. These things you have to write in the first paragraph. And the next paragraph is difference between money bill and finance bill. All money bills are finance bills, but all finance bills are not money bills. Tell me how many of you wrote this statement? But this is an important statement. All money bills are finance bills, but all finance bills are not money bills. So here only one boy, I think, have drawn the diagram. There will be a round big circle in that small circle. A big circle is finance bill and the small circle is money bill, which I have discussed in the class. Okay, but most of you did not write. All money bills are finance bills, but all finance bills are not money bills. And money bills and finance bills type 1 and type 2. You have to write the difference. First of all, money bills can be introduced in Lok Sabha. Finance bills type 1 will also be introduced in Lok Sabha. Finance bills type 2 cannot be introduced in can be introduced either in Lok Sabha or in Rajya Sabha. Second difference, a money bill, whether it's a money bill or not, decided by the speaker. With respect to finance bill, such differentiation cannot be done by the speaker. And third important thing, finance bills type 2 will be passed like an ordinary bill. Finance bills type 1, though it will be introduced only in Lok Sabha, after getting passed in Lok Sabha, the ordinary law procedure will be followed the finance bills type 1 also. This difference exactly most of you did not write. Finance bills type 1, finance bills type 2. And the article of Finance Bill 117 of the Indian Constitution, and few of you wrote 112, 113, whatever you like you wrote. Whatever you really like, and writing wrong answers and wrong cases is a blunder. Wrong answers and wrong cases is a blunder. So this is the second question and answer. And third question, critically account for low voter turnout in urban areas in India. Next question, critically account for low voter turnout in urban areas in India and suggest measures to improve the same. So first of all, this question is asked to make you to think about recent elections. Do you remember in December 2018 in Telangana elections, there was a big furor that in Hyderabad only around 48% of the people went and voted. If you compare to rural Telangana and urban Telangana have not went for voting. In the recent Lok Sabha elections, if you see Bangalore city, if you compare with Karnataka, the city votes are very less. The urban voters are not going for voting. In the same way, overall India, if you see the election results, urban voters are few. This data I want. You wrote the reasons, but you should have introduced your answer with Telangana example. Every newspaper carried an article why Hyderabad have not voted. This is the issue. So here, most of you have not, there was one important thing called SVEEP, Systematic Voter Education and Electoral Participation. There was a awareness campaign, SVEEP, that you should have mentioned. And more importantly, why urban voters? Most of you wrote urban voters considered as a pay holiday, yes, right. Second thing, urban voters are apathetic, they are indifferent towards electoral process, yes, right. According to a study, when urbans go and vote, they vote for less corrupt people, and also they won't take much money in voting, and also they won't vote for criminals, yes, it is right. And urban voters generally feel about transport system because polling booths are far away and political parties cannot arrange all the transport in the urban areas, yes. Some of the private offices till recently have not given holiday even on the poll day, yes. So there are various things which are right, but there is one more thing, logical thing which you went missing, that is duplication of electoral rolls. Most of the urban India go to the rural areas for voting, though they have, so they will have they will have their vote in the rural area and also urban area, and most of their votes are in there because their roots are in the villages. They will go to the villages and vote. They won't stay back in the city. If you see on the election day, before the election day, there will be a traffic jam in the highways because urban India goes to rural India for voting. That point is missing. Okay, and also social media campaigns. Duty to vote should become a fundamental duty for everyone, and also pride of being a voter, and we need to even celebrity campaigns and voter awareness programs, and more importantly social welfare scheme should be linked with your duty to vote. Those who go and exercise this duty, compulsory voting process, at least if not compulsory, at least there should be a duty, and a dignity and respect should be carried along with voting. All these things can be suggested, and more importantly in India voter turnout is coming down. That also you should do, except in the present elections voters turnout went. How to improve the voting? All these things you have to suggest. Okay, next question. Examine the need for the creation of state legislative councils and their role in the functioning of the democracy. Examine the need for the creation of state legislative councils and their role in the functioning of the democracy. Here, there are two parts of the question. First part is need for the creation of state legislative council, subheading petali. You have to give a subheading. Second part is role of state legislative councils in the functioning of the democracy. Second subheading. The answer should be divided into two equal parts. So you should start with the dialogue of bicameral legislature. You should start with the statement bicameral legislature. In India, 7 states have bicameral legislature. Only few wrote about the names of the states. It is better to mention in the first paragraph because only 7 states have. Why this question is asked? 6 months back, Orissa State Legislative Assembly wanted to have a legislative council. Explain the need. It will check the hasty legislation, right? It will provide a platform for expertise. It will also allow to discuss and debate various important public policy things. And having a permanent body is always good in the regional political setup. There is a need of state legislative council. Role of it in functioning of democracy. See, democracy is now turning into populism because of lower houses, right? Democracy is now turning into populism because of lower houses. Lower houses think about vote bank and politics. Better to have a effective body to discuss about public policy. This is the first point. And second point, in the lower houses if you see, the time is being wasted in political allegations. Recently if you see state legislative assembly debates in Andhra Pradesh, you will understand this. Whereas the elite body, or we can say the body with elders, the upper house can definitely discuss about better things for effective democracy, and it will also check the populist policies of the lower house. So in this manner you should write, but most of you have missed a point called Article 169 of the Indian Constitution deals with creation or abolition of legislative council. Article 169, creation or abolition of legislative council. But while writing in the functioning of democracy, poor states cannot afford this because poor states cannot afford legislative council because it is too costly. It is costly. It provides extra burden to the exchequer. So it is not so easy. Public money will be wasted and it will become asylum to political refugees. Those who lost their elections or those who want to get better seats, they will become that. So even those points will add half mark to your answer. Okay. Next question. Even in the fifth question, I am reading fifth question. Even in the matters of religion, individual freedom prevails over purported group rights. Critically analyze the statement. Most of you missed the point. Underline the key word in the question. Critically analyze the statement in the context of Supreme Court verdict on Sabarimala. Critically analyze the statement in the context of Supreme Court verdict on Sabarimala. See, right to equality, right to personal liberty, right to freedom of religion, they are all individual rights. Group rights, that is right of the religious minority or majority to have their own system, culture and custom. So nobody properly defined what is an individual right and what is a group right, unfortunately. Nobody have mentioned proper articles with respect to Sabarimala case in your answers. Okay, individual rights, and what question itself speaks about, even in the matters of religion, individual freedom prevails over group rights. So you should tell what is individual freedom, and these are the keywords of the answer. Individual freedom and group rights. And next thing is critical analysis statement in the context of this. You are expected to write more about Indu Malhotra's dissenting note. Indu Malhotra, there are 4:1. Girl write 3:1 judgment. It is 4:1. It is 4:1. In the 4:1 judgment, Indu Malhotra told she has not negated the women's right to enter into temples. She said, in the matters of religion, the Supreme Court, that the judiciary should follow certain restraint and should allow the society to take a call on it rather than the judiciary, because in each and every issue if judiciary interferes, so that is her thing. If you understand, critically analyze the above statement means you should also speak about Indu Malhotra, her view, because we should also consider the role of the dissenting judge here. So that I have expected in the question. Next question. Discuss the limitations of recent, sixth question number 6. Discuss the limitations of recently introduced electoral bond scheme. Discuss the limitations of recently introduced electoral bond scheme and suggest measures to improve transparency in political funding of elections. Suggest measures to improve transparency in political funding of elections. This is the important thing. Here you should understand electoral bond scheme. First of all, nobody defined what is the scheme. What is this electoral bond? No one exactly defined. Even the students who wrote mains last year. Nobody actually said what is electoral bond scheme. Electoral bond is like a promissory note which can be redeemed within 15 days, 15 working days. It will be given in the multiples of 1000, 10,000, 1 lakh, 10 lakhs, 1 crore. SBI is a designated bank to purchase electoral bonds in the prescribed time. And this is the definition of electoral bond. First of all, you should write the definition of electoral bond. And second thing, this question is not what is electoral bond. First sentence you should start writing what is electoral bond and immediately subheading limitations of electoral bond scheme. The challenges and limitations of electoral bond scheme. See, actually the scheme is meant to promote transparency in the electoral funding. But unfortunately, first thing, anonymity. Anonymity means in the political system, what we need is transparency, but the name of the donor and the name of the political party to which he has donated will be out of public domain. First thing. Second thing, SBI is a designated body, but the data of SBI will always be with the government because SBI is a government bank, public sector bank. And most importantly, the cap of 7.5% of the profits. Till this scheme was in vogue, before this scheme have come, the companies can fund to the political parties only up to 7.5% of their last 3 years average profit. But unfortunately, after this scheme, the cap was opened. So there will be nexus between companies and politics. And it is just an eyewash. Instead of promoting transparency, it will promote opaqueness in the system. And even sometimes multinational companies might stash out their bogus money, or binami companies. And companies run by politicians in the binami names can fund the political parties. You cannot say to what extent it will go. And political parties do not come under RTI. So these are all the limitations of electoral bond scheme, which you should have explained in detail. And more importantly, suggest measures to improve transparency in the political system. Suggest measures to improve transparency in the political funding of elections. First is state funding of elections. Inderjit Gupta committee recommended state funding of elections. Second thing, there should be a national election fund where donations and money will be deposited, and Election Commission of India should distribute the money to the political parties. And third thing, rather than electoral bonds, all these things, try to reduce the expenditure in elections. In the last elections, it seems that around 60,000 crores was spent just by political parties. They have spent more than 30 to 40,000 crores, and around 12 to 15,000 crores was spent by Election Commission of India to conduct the elections. Rather than trying to improve, introduce electoral bonds, why don't you reduce the spending on elections? Even this is the thing. So you can suggest measures, beautiful measures. This exactly pinpoint, if you write, you can complete in 6 minutes. Exactly, if you write according to the question, you can complete the answer in 6 minutes. There is no doubt about it. Next question. The freedom of speech is not an absolute freedom. Question number 7. The freedom of speech is not an absolute freedom, but was limited by reasonable restrictions. First statement. And in this first statement, most of you wrote Article 19, some of you wrote 19.1. Freedom of speech and expression 19.1a. Article 19, Clause 1, Clause A. Kindly refer your answer sheet. And how your teacher will feel who taught you polity if you write Article 19 and leave it. And I also gave in the statement, freedom of speech and expression have a restriction. There are reasonable restrictions. That is Article 19, Clause 2. You are expected to write some of the important restrictions, some of the important limitations of freedom of speech and expression. But most of you, except one, nobody mentioned 19, Clause 2. Okay, this is a blunder again. And this is the first statement. First statement, you are expected to write about freedom of speech and expression and its restrictions. And second paragraph, conflict between freedom of speech and defamation. Why I have given this question? I have given this question on the immediate reason about a journalist getting arrested because of his tweets on Yogi Adityanath. Okay, freedom of speech versus defamation. Okay, journalist getting arrested. And in the classroom, I have discussed freedom of speech and expression versus defamation cases. If you could remember, 5 years back, Outlook magazine have given an article on Smita Sabharwal indirectly, without naming her. This is called innuendo. Innuendo, I-N-N-U-E-N-D-O. Innuendo means indirect reference. Also amounts to defamation if a reasonable man can understand the meaning of it. Innuendo is a part of defamation. Nobody wrote. Innuendo. Innuendo means when a reasonable man reading the article understands to whom the article is meant for, to whom the article is addressing, that comes under innuendo. Even that comes under defamation. Okay. Every person have the right to protect his self-respect. Even a dead person can also file a suit. You can question me how a dead person can file a suit. The relatives of the dead person can file a suit when somebody defames a dead person. But it has become very common nowadays, making movies on the persons who already died. That is a different issue. So, Article 19 1A versus restrictions, and defamation is also a restriction. There is a thin line between freedom of speech and expression. For example, there is a thief who got convicted. In your newspaper or electronic media, you can call him a thief because truth with genuine evidence and truth with genuine facts you can present. But you cannot write allegations or averments without any evidence. So even this point you have to add. And then I have given many cases on freedom of speech versus societal dignity and other issues. Like if you could remember, Sanjay Barua making and unmaking of Prime Minister Manmohan Singh, that particular thing. Sanjay Barua's book, and Perumal Murugan's Maduro Bagan. So I have given 2-3 examples of it. You should have written more examples. Okay, bring out the conflict. This is the thing. How to draw a fine line between individual right and freedom vis-a-vis self-respect. We cannot draw a blanket distinction between individual freedom versus freedom of speech versus defamation. It should be decided by case to case, situation to situation, circumstance to circumstance. This is the conclusion. Case by case, situation to situation, circumstance to circumstance. This conclusion I expected. So we cannot say a single note, this is freedom of speech and this is defamation. It's a very thin line. So by seeing the case to case. For example, recently Kancha Ayalaya wrote a book on Samajika Smuggler in the title. Supreme Court said a book is, there is no wrong in the book. So each and every case you should see. And recently you all know Lakshmi's NTR movie. So right to freedom of speech and expression versus defamation. Okay, and the movie was banned in Andhra Pradesh till the elections got completed. Even movie on Narendra Modi, it's not about defamation, but it's about populism. So these things you need to mention. And next case. Examine the various steps taken by the Election Commission of India to exclude criminals entering into politics, with specific emphasis on recent Supreme Court judgments. The question have 2 parts. First of all, steps taken by Election Commission of India, and the second part is emphasis on the Supreme Court judgment. Okay, what are the recent Supreme Court judgments? So you need to address 2 parts of the question, and I wish to tell you, you should have started this question with the recent survey made by ADR, Association for Democratic Reforms, stating that 169 MPs of Lok Sabha in the 16th Lok Sabha have criminal charges on them, out of which 100 have heinous criminal charges. Out of which 100 have heinous criminal charges. If you would have started your question in this manner, definitely examiner will take more interest on you. Because you are talking with your data. You are telling your answer with some data. Okay, this is the data. And Supreme Court, before going to Supreme Court judgments, you should have written Election Commission of India. All criminal antecedents of the contesting candidates should be filed during nomination. How many cases he have, how many criminal charges he have, and this data after elections are over, they will upload in mynetha.com. MyNetha. If you type your MP's name and go with MyNetha, you will see how much property he has, how many criminal charges he have, what are the cases, IPC sections on which his cases were booked against him, all these things. This was a wonderful step taken by the Election Commission of India, and every voter before voting can understand by knowing their nomination papers how they are going to vote for that particular criminal. Okay, this is first thing. And next thing, Election Commission of India understands the nexus between criminality and money, trying to discourage the role of money in politics by having model code of conduct. This you would have written in the first paragraph. And the next paragraph, steps taken, the recent Supreme Court judgments, heading Section 8 Clause 4 of Representation of Peoples Act 1951. Section 8 Clause 4 of Representation of Peoples Act 1951 said that if a legislator gets convicted by a lower court, if he appeals within 90 days, that is 3 months, he will continue as a legislator. He can continue as a legislator. But in the year 2013, in Lily Thomas and Jan Chowkidari cases, the Supreme Court said if a legislator gets convicted for an offence which is punishable for more than 2 years by a lower court, even if he appeals, he should vacate from his seat. You all know in 2013, Latha vacated and went to jail. Shashikala in 2017. So these are the glaring examples. And but in India, accused person can contest in elections. Only a convicted person cannot contest in elections. Okay, only a convicted person for more than 2 years punishment cannot contest in elections. And last year there was a PIL filed in the Supreme Court asking the Supreme Court to direct the government not to allow, to direct the Election Commission not to allow the person on whom charge sheet was filed to contest in elections, which Deepak Mishra said, this is a job of Parliament to make an effective law, and if judiciary makes a judgment on it, gives a judgment on it, it ends up with overstepping into the domain of legislature. I expected even this statement in your answer sheet. Okay, so this is the next thing. Minimum this is the content of your answer, should be the content of your answer. Next, question number 9. Niti Aayog is created to redefine cooperative federalism. So first statement of the question is Niti Aayog is meant for redefining cooperative federalism. But in the last 4 years experience, it is acting like old wine in the new bottle. Examine. Actually, just the day on which I am preparing your question paper, I have seen the same heading in Hindu. Niti Aayog, old wine in the new bottle. So I want to make you to write an answer on this because I thought similar question might come in the exam. But I have not given a drastic statement and I have given examine. I asked you to tell whether it is right or wrong. Examine the statement, but most of you supported the statement. I think you got the point. I asked to examine the statement, but you have supported the statement. I have not asked you to support the statement. I asked you to examine the statement. Unfortunately, that was not done. So I will tell you now how to examine the statement. Listen. Niti Aayog was created in the shoes of Planning Commission. It's a dream of Narendra Modi, and as Planning Commission outlived its utility. Niti Aayog is meant for bottom-up approach and decentralization model, and as Planning Commission follows one size fit for all model approach, Niti Aayog do not follow this model. In fact, Niti Aayog acts like a think tank, and Niti Aayog is expected to promote research, not just, and Niti Aayog is not a constitutional body, not a statutory body. This should be the first paragraph of your answer. And cooperative federalism is a major idea behind Niti Aayog, as states will be given major role. But unfortunately, you have seen Mamata Banerjee and important leaders have excused themselves from attending the Niti Aayog conference, stating that Niti Aayog is a old wine in the new bottle. They are not allowing the states to present their problems in the Niti Aayog. That was the allegation. That was just an allegation. But judging the performance of an institution which is of national eminence, national importance in 4 years span is a premature argument. You cannot judge it within 4 years how Niti Aayog performed. Second important aspect, Niti Aayog have refashioned itself as a think tank and research not only government people but also experts. So Niti Aayog, you all know Atal Innovation Mission, Composite Water Management Index. It have given a paper on artificial intelligence. From last 2-3 years, if you observe, even about the diseases, particularly non-communicable diseases, Niti Aayog advised many things to the government. There are various things which Niti Aayog have done from last 2-3 years, though with some shortfalls. It is too early to decide that Niti Aayog is a failure. It is better to consolidate the working style of Niti Aayog. As you all know, there was a criticism that it is acting like a old wine in the new bottle. The same structure which Prime Minister is the chairman, and the same structure where controlled by the center and state, though regional parties, regional systems expect more from Niti Aayog, they were not allowed to a top priority to speak from their own heart. So better space should be given to the states, and the true spirit of federalism should be enriched in Niti Aayog, and Niti Aayog should be consolidated as a team, as it is going to promote Team India. Team India, this should be the answer. Rather than supporting the statement, you should have driven that Niti Aayog it is premature, Niti Aayog have done so much, but Niti Aayog is now many states are criticizing it is a old wine in the new bottle. The reason is it is still inclined towards center, less inclined towards states. So it is better to consolidate it and better to give more space to the states and their problems rather than making it as a outmoded mundane organization. This should be the answer. Okay, next. Mention lacunae in existing criminal justice system in India to rectify the same, with a specific emphasis on Malimat committee recommendations and suggest measures needed. Actually, I have given this question for 2-3 reasons. Recently, you have seen various crimes, increased crimes and delayed justice, and you can start even this answer with delayed justice is nothing but denied justice. What are the problems in criminal justice system? Low conviction rate, lengthy trials, even our trial prosecution is too bad, third degree methods by police, atrocities by police, no summary trials, too much of expenditure, no lacking of evidence, no circumstantial evidence. There was no technology used in catching the criminals. So there are various problems in criminal justice system in India. There is no coordination between police of one state to other state, because crimes almost are pan-India, but policing is a state subject. So these are all the areas which you need to mention, the lacunae in the criminal justice system. And Malimat committee recommendations, it is way back almost 18-19 years back. But in 2018 again a debate have come. Why don't you immediately implement? Some of them are being implemented. Why don't you immediately implement more and more Malimat committee recommendations? I will tell you the recommendations. Even if you understand 4 or 5, it is important. It is enough. One recommendation is, why don't you convert present adversarial system into inquisitorial system? Why don't you convert present adversarial system into inquisitorial system? What do you mean by this adversarial system? If you see the court proceedings, on the one side there will be a public prosecutor and on the other side there will be a defense lawyer. They will be arguing and the judge will be sitting and listening. In the inquisitorial system, judge will take an active part in the investigation. Rather than a silent spectator and finally delivering the judgment, judge will take an active part. Okay. In most of the Western countries, they follow inquisitorial system, whereas in India we follow adversarial system. So this is the most important recommendation. If judge becomes an active part, he can pinpoint, because in criminal justice system we all know law is blind. Law always needs evidence. For there is no evidence, there is no judgment. And the accused, As you all know, let the 100 culprits escape, one innocent should not get punishment. And burden of proof is very difficult in India. It's very difficult to prove the crime in India. Even 99% of the rape cases we cannot prove. Only 1% of the rape cases can be proved with evidence. 99% of the rape cases we have only circumstances. Okay, it's very difficult to prove a rape case. So for all these things. So first thing, so it should go to inquisitorial system. Second is right to silence. Right to silence. Article 20 clause 3, you all know, protection from self-incrimination. But most of the times police will make the person to tell the truth, sometimes untruth. So right to silence. Next is rights of the accused should be protected. Rights of the accused. See, in India, if a person is accused in a crime, society will decide that he was a culprit. Even media will decide that he was a culprit. Media house will sit and decide what happened. Before the court gives a judgment, media will decide the fate. Even this should be stopped. Right of the accused to be, in the hidden way, rather than his name, his titles, entire thing comes out in the media. And presumption of innocence. Presumption of innocence. See, presumption of innocence till beyond reasonable doubt, till the guilt is proved beyond reasonable doubt. There was a statement in criminal law. But all the cases we cannot prove beyond reasonable doubt. Even this should be reconsidered. And other thing, justice for victims in the crime. Justice for victims in the crime is X raped Y or X murdered Y. You punished X, but what about Y's life? What about Y's life? You should have done something to restore Y's life to an extent which you can do it. Because once there is a murder, you cannot restore life. But his family, once there is a rape, you cannot restore the life of the girl. But at least to an extent, rehabilitate her. So even this victim compensation should be a part of criminal justice system. Likewise, there were various things which Malimat committee discussed. At least if you 3-4 you should have written, it will be good. But as you all know, in UPSC, 2-3 questions look little vague. For those who have not studied well in criminal justice, you don't know, I know Malimat committee, but at least 3-4 points you should try to understand. Next question is the 11th question. The doctrine of basic structure is not static but dynamic. The doctrine of basic structure is not static but dynamic. Explain how the Indian judiciary evolved the doctrine of basic structure case by case with suitable examples. There were 2 points in the question. The doctrine of basic structure is not static but dynamic. Explain how Indian judiciary evolved the doctrine case by case with suitable examples. Okay, so you should write what is basic structure. The word basic structure is not defined in the constitution. It was emphasized in the case called Keshavananda Bharati versus State of Kerala, and the judges gave some points in the basic structure that you have mentioned, and then the judges told the doctrine is not exhaustive but illustrative. They kept open to add new theories in the basic structure so that fundamental rights of the citizens and constitutional fabric will be protected. And the second part of the question you should have addressed by writing Indira Gandhi versus Raj Narayan, where rule of law, free and fair elections. Rule of law, free and fair elections are considered as basic structure. In the same way, Minerva Mills versus Union of India, where judicial review and harmonious relationship are balanced between fundamental rights and directive principles is a basic structure. S.R. Bommai versus Union of India, where it was mentioned that secularism is a basic structure. All these things you would have written effectively. Okay, this is the gist of the answer. Next, question number 12. Give gubernatorial. See, whenever you use the word governor, you should use the word gubernatorial. Intentionally I have given the word gubernatorial. It's a very fine word to use to narrate about Governor. One answer sheet I have read. Governor in the state is less powerful than the president in the center. This is a very wrong statement. I rounded it up and said it's wrong. Just check it out whose answer sheet it is. Okay. Gubernatorial post of governor in the constitutional scheme of things has been structured with the power of right to warn, right to be consulted and right to be informed. So each and every word in the question is important to narrate. Why the statement was given to you? You are expected to write on these first two paragraphs. Because this is a 15 marker question, you are expected to write first two paragraphs on this. So you should start writing with constitutional articles with respect to governor. And I particularly emphasize on article 163 where the word discretion is used. Article 163 where the word discretion is used for the governor. And more importantly, right to warn, right to be consulted. This particular statement I have taken from an article published in Hindu in the lead page 1 year back, when the judgment on Delhi Lieutenant Governor case have come. The article is written by Gopalakrishna Gandhi. In that article, he told, the governor is not mere a decorative piece. The governor is not mere to arrange tea parties and to conduct Republic Days and Independence Days. He has a function to perform. Whenever the government does something wrong, goes grossly wrong, he has a right to warn. And whenever there is a constitutional crisis, he has a right to be consulted. And according to Article 167, there should be a regular information communication between the Chief Minister and the Governor. So I expected 167, but nobody wrote. Okay, and bring out the recent instances where the posts have become controversial. First thing, Karnataka, even in the appointment of pro tem speaker, even in calling the BJP to form the government, and BJP could not prove the majority, even this case, and Tamil Nadu where government started interfering, and Puducherry and Delhi where Lieutenant Governor started fighting with the incumbent legislative system, and the 2016 instances of Arunachal Pradesh and Uttarakhand, you should have mentioned, particularly Article 356 where governor misused the power in various cases, and as B.R. Ambedkar said, it's a dead letter of the Indian Constitution, but the most misused letter. And whether we should have a governor, definitely we should have a governor, but governor should be non-partisan and unbiased. This was the thing. Coming to question number 13. Legislative impact assessment mechanism will help India to improve quality of legislation and promote good governance. Explain the significance of LIA and its challenges. Legislative impact assessment mechanism will help India in improving quality of legislation and promote good governance. Here, if you could understand, the question have two components. Quality of legislation and promote good governance. You need to address the two aspects of the question. There are two aspects. Before going into explain the significance of legislative impact assessment and challenges, first of all you should write how legislative impact assessment will enhance the quality of legislation and promote good governance. So now I will give you examples how it will improve. Before making a public policy or legislature or a law, first of all a panel of experts encompassing various members in the society should sit and study what is its impact, whether it is going to create a majoritarianism or whether it is making the minorities to suffer, or whether, for example, triple talaq ordinance, instant triple talaq ordinance where 3 years punishment, Aadhaar where right to privacy is being affected, and a policy on BT Brinjal. So all these things are really affecting good governance. There is wide debate in various sections about triple talaq ordinance. even Aadhaar, even BT Brinjal in the recent past, even insolvency bankruptcy code, within 1 year they started amending the code. Within 1 year they started amending the code. So all these things you should have made an exercise to study on that. Okay, for good governance and quality of legislation. See, as you all know, most of the draft legislations are kept in public domain for people's approval. You can send your comments, all those things. Even if you approve or not, it will get passed. That's a different issue. When your representatives are okay with it. But the thing is, you can give constructive suggestions. But how many of us, even the educated Indians, are reading the draft legislation? Recently, we have draft national education policy. Any one of you have sent any recommendation on that? So this is the thing. Quality of legislation will be improved when there is a large scale public debate on the draft public policies and various issues get addressed, and lots of parliament time will get wasted not to make the law but to amend the law. Even most of the laws in the recent past are being amended regularly. So why do even Lokpal, see, if you see, Lokpal has not been appointed for last 6-7 years because leader of opposition is not there. But if somebody would have predicted this type of situation, they would have made the law leader of opposition or leader of single largest party. So these things will be avoided and extra effort, energy and money will not be wasted when you presume it, when experts really think about it, because visionaries really work with 100 years of vision, and when you make a law, it will be very strong. And I will give an example. Here I am not praising the Britishers. Indian Penal Code 1860. If you read even today, you will feel that it is really modern and really perfect. Though we have some sections like section 377, section 497, there are some sections which are outdated, but still I can say it was one of the finest texts. Even after 200 years, if you sit and read, you will feel that it is very, very relevant. Such types of luminaries are required. Unfortunately, we are getting lawyers but not legal luminaries. Even that was the thing which you have to understand. So what we need is good governance, at the same time quality of legislation. And second part of the question, explain the significance of LIA and its challenges. Challenges. The problem with the challenges is, see, too many cooks spoil the dish. Too many cooks spoil the dish. So if new legislation is coming, if you consult wide variety of people, definitely there will be a diversified and counterproductive clauses in the legislation, and there will be environmental activists coming in front of development, and developmental activists coming in front of environmental activists. In the same way, someone wants national interest, someone wants right to privacy. So there will be confrontations between opposition parties, ruling parties, elite groups and communists, various ideologies, because India is such a large diversified country. We cannot make everyone happy with studying the impact, but the thing is, at least all sections of representatives should be consulted before going to that. And in the countries like Finland, Kenya, we have legislative impact assessment working very well, but unfortunately the major challenge is India is a wide diversified country. For that reason, we have a mechanism in India called delegated legislation, which we can use effectively. Even that you can suggest. So the main framework of law can be done by the parliament. The broad framework of law can be given by the parliament, and the rules and regulations based on the uniqueness of the place and peculiarity of the place, regionalism, can be addressed by bureaucrats or regional political systems, rather than everything controlled by the central government, the parliament. Even this you can suggest. So effective utilization of delegated legislation with proper checks and balances can also help in promoting the significance of legislative impact assessment. But even general public apathy over legislatures. So people, unless it gives some benefit, immediate benefit to them. If it is something like MG Narega, people understand. But if you have an act called RTI Act, if you go and ask in the rural areas how many of them know about RTI Act, very few of them will respond positively. The reason is, people want this public policy for welfareism and populism, not for future generations and their impact. Even that is the thing which you have to address. We have in government, we have a division called information division, We have a civil services. In civil services, we have a service called Indian Information Service, which needs to publicize legislations and also public policies and various schemes and programs started by the government. Except for UPSC, we don't read all these things. Okay, coming to the next question. Question number 14. In the recent times, there has been a debate over productivity of the parliament. What are the major reasons behind it? I am repeating, in the recent times there has been a debate over decline in the productivity of parliament. What are the major reasons behind it? Suggest measures to improve parliamentary productivity. So you should have started. Parliament is a temple of democracy and its productivity reflects in the productivity of the country. You should have introduced your answer with exceptionally fairest words about our parliamentary system. Okay, and you should have written about the 16th Lok Sabha, the productive use. The 16th Lok Sabha spent 40% less than the average number of hours spent by its predecessors. The 16th Lok Sabha spent 40% less time than the average number of hours spent by its predecessors. Disruptions and adjournments also took most of the time of Lok Sabha. Disruptions and adjournments. If you study the 16th Lok Sabha, the bills passed in the Lok Sabha are 133 and worked only for 1600 hours. 1600 hours. The second lowest by the House that completed the full term in the last 70 years. 1600 hours, around 1615 hours. The second lowest by the House that completed a full term. It was analysis not by me but PRS. Okay, and you should have drawn a proper diagram. You should have drawn a proper bar diagram on this. Okay, so Lok Sabha 1 around little less than around 3,800 hours. Lok Sabha 2 like that. I'll send you the diagram. I'll make a thing. So how the graph have come down? How the graph have almost come down? 12th Lok Sabha is the worst. You should have given in a pictorial way. It would be a best way of representation. Okay, this answer you should have written with lot of data also. Data was also missing completely. And even Rajya Sabha, the performance of Rajya Sabha is coming down. Productivity of Rajya Sabha is around 20-25%, Lok Sabha is around 40% in the recent past. So with percentages, if you have written, it would have been better. This is the first paragraph of the answer. And second paragraph, what are the main reasons behind it? You know that main reasons is party politics rather than constructive action. Partisan role of speaker and rather than consensus, no private member bills, government dominance and opposition parties, even fake no confidence motions to appease people and personal allegations and averments rather than constructive debates, wastage of parliamentary time with petty politics and all these things. These are the major reasons behind the decline of the parliament. Suggest measures to improve parliamentary efficiency. To conduct parliament for every 1 minute, it costs 2 lakh rupees. So, first thing, there should be a track of each MP's performance individually and collectively. First thing, attendance track, you all know there is a track, but the MPs, their qualitative time should be allowed and political parties should be strictly warned to take care of their MPs in that respect. First thing. Second thing, even private member bill should be properly discussed. And third important thing, in the parliamentary productivity, increase the hours of parliamentary sessions and more than 10-15 minutes if somebody wastes parliamentary time, he should be properly warned or properly fined. And more importantly, even people should watch the, we have directly live Lok Sabha TV, Rajya Sabha TV, state assemblies. People should watch how their MLA or MP is performing, whether he is debating on public policy or talking, countering all these things. Even that they have to follow. And next important thing in the parliamentary time, we have various parliamentary committees. When there was a deadlock or debate, we can send the particular bill or policy to the committees to study about the particular eventuality, all these things. And even Prime Minister, the people who are in the government should take care that parliamentary time should be used in productivity. The major role here is played by Speaker. Even Speaker should be responsible for that. Speaker's post should be meant for that. So all these things you have to discuss and debate about the parliament. And I can tell you a simple solution. People with elite mindset, people who are selfless, people who are educated, if they go into the parliament, they won't interfere into petty politics. Unfortunately, if you see our parliament or state legislative assemblies, you will be feeling really bad by seeing the people who are sitting there. The quality of the people who are entering into the system will be, if it gets improved, automatically the productivity will get improved. Okay, question number 15. Common sense and logic are the two essential virtues in civil services. Elucidate how the public service commissions are ensuring the above rights. Okay, elucidate means explain. I am not asking you to examine. I am asking you to elucidate. Is lateral entry system antithetical to loyalty and trustworthiness? So, I have taken this common sense and logic statement from Britain. In Britain, there is a very famous statement. Common sense and logic are the two essential virtues who should enter into civil services in Britain. Even the same model we have followed. To improve the rationality of thinking, public service commissions, what they have done, they ask the student to know wide variety of things which is happening around us. So, expecting things from budget to economic survey to governor's post to political system to elections to BT Brinjal to recent science and technology developments to PSLV versus GSLV, each and everything they asked us to learn to analyze the things so that we will improve our common sense and logic. Rather than rote learning, we are expected to use our rationality by applying our day-to-day observations in our system. The examination will make us very patient so that it will allow us to think more and apply our rationality in a practical way. You all know the administrator called Muhammad bin Tughlaq, though he was very knowledgeable, but he cannot be practical in administration. What we require is this administrative tactics, administrative methodology rather than just rote learning. So here, if you observe 2-3 instances, like say in our public services we have E. Sridharan, Delhi Metro, how he used his practicality in making metro successful in solving the problem of traffic in Delhi, so that other cities in the states are emulating the process. In the same way, we have one more civil servant called T.M. Seshan, who practically started various reforms in the elections. Even that was a great achievement. Even there are many important administrators who have created a lot of difference. I will give you a small example. In 2004, during we have tsunami, a very bad disaster in India, and there was a collector called Mr. Radhakrishnan. I think his name is Radhakrishnan, in the district called Nagapattinam district, where thousands of people died and all the dead bodies are mounding in the areas, surrounding in the areas. Immediately he called a village in Tamil Nadu which is efficient in burying and burning the dead bodies. Within 24 hours, dead bodies were cleaned up. Though it was emotional thing, he has dealt the issue very practically, because with dead bodies, lots of diseases will come and it might affect. So, there is no doubt that public services commissions are ensuring the best of logical brains and thinking brains by testing our patients, you all know, by conducting prelims, mains and interview in the long run. That is no doubt about it. And is lateral entry system antithetical to loyalty and trustworthiness? Last year, there is a wide debate about a concept called lateral entry system. Already government have recruited 10 joint direct level officers to the lateral entry system. What is, first of all, you should start lateral entry system is without writing the civil service exam, those who have experience in private sector or public sector units can directly enter into joint direct level cadre. This is the thing. Here, yes, they might have knowledge and experience, but as from the beginning, when you pass civil service exam, you will start developing a sentiment, a trust and loyalty towards government, towards public, towards people, and you will start preparing for this exam with service motive. But suddenly the person who was very skillful from private sector might not have same empathy and loyalty, empathy towards people and loyalty towards government. But it is a very subjective thing which you cannot expect that every government servant will be loyal, or which we cannot say that every private servant is disloyal. It is case to case. But while allowing people directly through backdoor entry or lateral entry, you should also ensure that track record not only in skills and knowledge but also in their competence of character. At least his past 10 years of track record should be studied, so that more than knowledge to an organization, particularly government, it is loyalty and competence which is very, very important. You have seen, say, we have various prime ministers in India, from Narendra Modi to Manmohan Singh. They are very loyal towards their cause, very loyal, very much loyal towards their cause. Though they have different ideologies, but their loyalty and commitment is very, very strong. There are very good government officers who shows tremendous loyalty. I have seen very good government officers without breaking a single rule. So they are perfect. But the same mindset, it's very difficult because it is nurtured through years. So this is a thing which you have to really debate about, but it's a very subjective question, very subjective question. So government, while allowing the private officers entering into the public, that is the government office, not only tests the knowledge but also how they are going to, why they want to work, not only to get the post or something else, but also. But in this question here, antithetical, here there are some chances of disloyalty. What are the chances of disloyalty? They may come into government for status or for some corrupt practices, a good salary, enter into the government and wanted to, and lateral entry system should be restricted for some time, because a person who came from outside, who have come from outside, should be allowed to work only for few years, not for more years, no extension. And sometimes their contacts, even some MNCs, they may work for private motive or profit motive, but government priority is welfareistic. Even this priority changes from private sector and government sector. A private employee think about the organization and its profit. A government employee will think about the people and their welfare. So if you see this distinction, it is not just knowledge and skill, it is about commitment and loyalty. Okay, I don't think it is very easy for a lateral entry person to suddenly step into the shoes of government servant to see from the eyes of government servant. It's not very easy. It is not very easy, because I have seen the exact difference between a government servant and a private servant. It was completely two different shades, two different dimensions of a person. Government service is not just about knowledge. Knowledge test will be up to only passing the exam. Beyond that, it is not just knowledge, it is common sense, it is logic, it is empathy, it is tolerance, it is welfareism, it is commitment. More importantly, it is patience, perseverance. Coming back to 16th question. Separation of powers does not mean creating watertight compartments, but to ensure proper checks and balances. I am repeating. Separation of powers does not mean creating watertight compartments, but to ensure proper checks and balances. How far Indian Constitution applies the principle of checks and balances, bring out the lacunae in the application of scheme of checks and balances. You should start this statement with Montesquieu, the spirit of the laws, and You should write separation of powers does not mean watertight compartments. Coordination but not confrontation. Coordination at the same time not encroachment. This meaning should come. One organ of the government should not encroach into the domain of other organ. At the same time, all the three organs of the government should cooperate. Here, I have seen Manoj Reddy answer. He has drawn a diagram. He has given a small basement, three pillars, and he has drawn three pillars. First pillar, second pillar, third. Legislature, executive, judiciary, and he has given a hilltop to it. A diagram hilltop to it. There, all should work for good governance and democracy. A very beautiful pictorial representation of how separation of power should ensure a proper democracy. So, small basement, three pillars and three diagrams. In the three diagrams, legislature, executive, judiciary, and he has given a top, democracy. So, similar pictorial representations can be given when while writing about separation of powers. And coming back, ensure proper checks and balances. Here you should write so many articles about India. Article 50, separation of judiciary from executive. Article 121, Parliament should not interfere in the affairs of the courts. 122, courts should not interfere in the affairs of the Parliament. Article 123, ordinance making for the President. Article 213, ordinance making for the Governor. Article 75, the ministers are drawn from the legislature. Article 79, President is a part of Parliament. So, all these articles you should use in the answer. These are the articles which you should use in the answer. Coming back again, checks and balance, judicial review, fusion of powers, particularly legislature can question the executive no confidence motion. At the same time, you should also see the removal of judges process. So, there are various issues here, how you are right about checks and balances. So, in India we do not follow strict separation of powers, we follow the spirit of separation of powers. At the same time, we also ensure checks and balances, because a very bad legislation can be questioned in the court and court can struck down in the name of judicial review. Article 13 of the Indian Constitution, and you can also say there is separation of judiciary from executive. Article 50. At the same time, if a bad judge is recommended who have done something against national interest, even the government can send back the recommendation, and the ministers can be questioned in the Parliament, and no confidence motion against the government. So, there are various checks and balances in the entire scheme of things in India. We cannot say it is completely strict separation of powers. So, you have to narrate this with a small diagram. If you draw the diagram, it will be very, very good. Should have given a very good diagram. Okay, next. 17th question. The Forest Rights Act envisioned to grant legal rights to the claims of scheduled tribes and other forest dwellers. The Forest Rights Act envisioned to grant legal rights to the claims of scheduled tribes and other forest dwellers. Explain the contradictions between the conservation of forests and protection of dwellers' rights in the light of recent Supreme Court stand of the issue. See, you all know scheduled tribes and other traditional forest dwellers act was passed in 2006, and not only STs but also those who are living in the forest areas from the last 3 generations, they are entitled to stay in the forests. Here comes recent Supreme Court order for the people who are illegally staying in the forest in the name of tribals and forest dwellers. They should vacate by July. Even based on this order, what is our contention? Explain the contradiction. Here, I expected that if you see our key sheet, Bishnoi tribe of Rajasthan, Chenchu tribe of Andhra Pradesh, particularly Maldhari tribe in Junagadh. So, the tribals are allowed to live in the areas where lines exist to conserve the lines. There was a sync between the forest dwellers, tribes and the forest. You cannot disconnect the forest dwellers and the forest. So, you can use the STs and forest dwellers so that the rights of forest dwellers and also forest can be conserved. See, 4 or 5 examples should be given how Aptani tribes, many tribes in the northeast, how they live in the forest and protect the forest. So forest dwellers and forests cannot be separable, This should be the second paragraph of your answer. Apart from that, you should write why the Supreme Court said that, what are the recent issues on the case. On February 13, Supreme Court ordered the eviction of more than 10 lakh families because they are all duplicate. They are not proper tribals or dwellers entitled according to the Act. So based on that, you should understand 2-3 points. One is, the Act itself is completely unknown to the forest dwellers. They have an Act, but how many of the tribals and forest dwellers understand the meaning? What is the awareness about the Act? First thing. So it is only the tip of the iceberg. There are lakhs and lakhs of forest dwellers still residing, and only a small fraction was identified. Most of them don't know their rights and don't have any awareness about the Act. First of all, this is a duty. The Act itself is a big thing. Lack of awareness building. And next important thing, the claims process. The claims process in the sense, see, it takes time to study the claim of the incumbent and also to consult the Grama Sabha and where to appeal. Even the appellate process is very, very cumbersome. Appellate process is also very, very cumbersome. And at the same time, most of the duplicate or binamis or people who are not entitled, they are living in the forest areas, wanted to use the forest rights. Even this has to be identified. We cannot say blanket, with a blanket order 10 lakh families should be sent out. Those who cannot show the evidence can be sent out, because most of the tribals and forest dwellers living in the area cannot show the proof of their existence from last 60 to 70 years. How can you prove that? Even this was the issue. So the local people committees, particularly Grama Sabhas, should be the way out to, they should consult and they should be consulted, and there should be a proper way out for this rather than giving a direct order. Recently Supreme Court issued a stay on it, no doubt about it, but still the issue, environmental conservation and protection of forest rights, at the same time protection of tribal rights, should all go hand in hand. Otherwise there will be big furor in the country, particularly you know that incidents where some tribal groups will not allow us to enter into their domain in the forest. Even that tribal groups, it is very difficult to list out them and identify them. It is not that easy. Next question. Progressive realization of responsible government, increasing participation of Indians in all forms of administration, and gradual development of self-governing institutions was a statement given in 1917 by Montaigne. How far these objectives were realized by Montaigne Chelmsford Reforms 1919? Question is, how far they were realized? I have not asked you to narrate them. You just tell how they got realized. First of all, they have introduced diarchy in the provinces for an eyewash. They said responsible government, but for an eyewash. They have not given any responsible government at the central level. Second thing, they gave bicameral legislature with lot of powers to the Governor General in the Governor's role. And third thing, even in most of the states, that is provinces, no proper devolution of items, because items were divided into reserved subjects and transfer subjects. Most important items were given to the Britishers, not Indians. Even the things which were made by Indian legislators, finally if Governor General vetoes it or Governor vetoes it, it can be stopped. So if you see various activities, even the franchise, even Indians were not included, even the franchise means the voting rights of the Indians were not increased. And Governor General's Governor's powers were absolute almost. Division of subjects were not satisfactory. Even Bombay, Madras, Calcutta, and the military powers are very, very high. So if you see all these things, progressive realization of responsible government. Self-governing institutions, no self-governing institutions. Only one thing they have recommended for Public Service Commission, rest all governance institutions were controlled by system. And including of participation of Indians in all forms of administration. Even Indians selecting for civil services are also low. This is a static question which you can read in any textbook. And the top 19th question. The topmost cities in the world have directly elected mayors. The topmost cities in the world have directly elected mayors. Does India need directly elected mayor in all cities to ensure effective realization of objectives of 74th Constitutional Amendment Act? See, 3 years back a private member bill was introduced by Shashi Tharoor with respect to direct election of mayor. It is up to the state legislature whether we should have direct elected mayors or not. Some states have introduced, some states have not introduced. Most of the states will have indirectly elected mayor. As we have the president for the center, we have mayor to the city. But as you all know, 31% of Indian population living in the cities today is going to be 50% by 2035, is going to be 70% by 2050. Directly elected mayor will be more responsible and accountable, and people can have access and contact, people can directly ask them, and the mayor who is directly elected can recreate the city with lot of difference, because if you see the topmost cities in the world like Tokyo, like New York, London, they have direct elected mayors. Mayor is very, very important. But the problem is, mayor in the Indian cities in most of the places is only symbolic. The first problem is municipal commissioner in most of the cities having more role and power. In a democracy, democratic leader should have a role. And this leader, to get elected again and again, he will try to develop his city and make it as a world class. As we are heading towards smart cities and other things, definitely we should have it's better to have a directly elected mayor. And the objectives of 74th Constitutional Amendment Act, as you all know, local self-governments, particularly municipal administration, should be very, very strong with effective participation. Cities have a lot of problems, and 74th Amendment Act wanted the city, that the municipal town administration, urban administration perfect. In urban administration, better to have in a democratic country like India, better to have a democratically strong leader to administer the city rather than a bureaucrat who is a municipal commissioner. This was the answer. The next question, how party system is structured in India? How party system is structured in India? Examine the criteria for the recognition of national parties and local parties. National parties and regional parties in India. How party system is structured in India? Indian party system is multi-party system. As on day we have 7 national parties and around 58 regional parties. And National People's Party might become very soon the national party whenever there is a revision. National People's Party belongs to Sangma. It can become the next national party. So how party system is structured in India? National parties, regional parties. In India we have multi-party system. This is what I expected from the first paragraph. Examine the criteria to recognize national parties and state parties. Because we have elections, you should know what is a national party, what is a state party. Simple detail. National party, first detail. Secure at least 6% of valid votes. Secure at least 6% of valid votes in assembly elections from 4 states and won at least 4 seats. Secure at least 6% of valid votes in the elections, 4 seats from 4 different states. Win at least 2% of seats from Lok Sabha, 2% of seats in Lok Sabha from 3 different states, that is 11 seats. Or the party is recognized as state party in 4 different states, as Trinamool Congress got victorious. This is how a national party will be decided. And if you see the regional party, state party, how state party can be decided. Secure at least 6% of valid votes and win at least 2% of seats in, win at least 2 seats, 6% of votes and 2 seats in assembly elections, secure at least 6% of votes and 1 seat in Lok Sabha election, win at least 3% of seats or at least 3 seats, whichever is more in assembly election, win at least 1 out of every 25 Lok Sabha seats in the Lok Sabha general election. If nothing is there, at least secure at least, if you don't win any seat, secure at least 8% of valid votes. This is a factual question. And national parties and state parties are recognized by Election Symbols Order 1968. Okay. So this is how answer should be written for this paper.